Ladies and gentlemen, on the issue of the police station and how the whole system works, or more to the point, how it should work, we're very lucky. We've got a number of police in our organisation, but we're extremely delighted to have amongst our many John Hurst, a policeman of 30 years, and he's going to tell us a bit about what we should know about dealing with the police. John Hurst, ladies and gentlemen.
Thank you, everybody. Just wait for it, make sure it comes on. There we go. I was a little late this morning. I have got an excuse. Somebody's tampered with my car. They've damaged one of the valves on the very near side wheel. I'm not making any allegations, but I found it very suspicious. About 2/3 of the rubber in the valve had actually been cut through. 2/3 of the rubber in the valve had been cut through, and it could well have been a blowout on the way here. So I mentioned that for what it's worth, but I'm here. I was Roger's advocate stroke Mackenzie friend on the day, which meant I couldn't join in the scrap, unfortunately. I was Roger's Mackenzie friend on the day. I couldn't join in the scrap, but Rusty was okay in the end. Is Rusty here? We're not sure. What I'm going to do is give you a short legal lesson. A short legal lesson. You have to bear with me because you need to know these things in case you do have dealings with the police. You have to keep the mic. And what I aim to do is teach you about what a policeman is and what his responsibilities are. And once you know what his responsibilities are, then you can perhaps insist that he does follow those responsibilities. And after that, I'm going to show you a short video, which is an encouragement in what you may do in the next few months. Okay, so a short legal lesson followed by a bit of encouragement. Here we go. The common law legal system we live in is adversarial. It needs test cases. It's no good sitting at home and saying, well, that's wrong and somebody should do something about that. It needs a person to stand forward. Stand up and be counted, and that's what we had on the day, wasn't it? Yeah. Roger had the evidence, and the other people stepped forward to actually lay hands on the judge. One did, in fact, did succeed in laying hands on the judge. He was undoubtedly arrested, and he escaped. And that means he's unlawfully at large, isn't he? He's unlawfully at large. But I have to tell you, the main objective of the day, this is Roger's decision, wasn't necessarily to arrest the judge, it was to get the police's attention. To get their attention and teach them a few things they didn't know, particularly about treason. Police have got no monopoly in making arrests. Everyone has a common law obligation to maintain the police, and the police don't have a monopoly. They tend to forget that, don't they? They don't like it when other people step in. They're accustomed to store detectives and that sort of person making arrests every day, but when it's more serious than that, it's a problem to them. Now, the subject's duties. The duty of the police to maintain the peace is initially based on the duty of the constable as an ordinary individual. So they have the same power as us, they have the same obligation to maintain the peace as us. Is that coming out all right? Does anyone know how to do that?
That's better.
There we go. Thank you. The duties of the individuals of the state. The individual is under certain common law duties to serve the public. In practice, he or she will now be called upon only in exceptional circumstances. Thus, although the maintenance of the order is the function of the professional police forces, every citizen is under duty to assist in the quelling disturbances and maintaining the Queen's Peace. House Resource Wing in 2004. And it's reciprocal. If a policeman calls for help, we've got an obligation to help him. And if we've got a problem, we call the police, they're supposed to help us. In plain terms, every person has a common law obligation to maintain the Queen's peace and prevent crimes, both as individuals and when called upon others to assist them. That's the reason why both private persons and member of police forces have powers of arrest and can call upon each other for help. Now this looks a bit complicated because this is a statute. But look at the bit involved. A person other than the constable may arrest without warrant. Now in legal terms, may means must. Because it would be neglect of duty when you're confronted by a crime not to do something about it, wouldn't it? So really, may means must. A person other than constable must arrest without a warrant anyone who's guilty of an offence, or anyone who has reasonable grounds for suspecting it. An example: a private person might witness a serious crime such as treason, fraud, or criminal damage, and therefore know that it had been committed. That witness would have a power of arrest. Other persons, even if they've not witnessed the crime themselves, will be obliged to assist in making the arrest if called upon by the witness. Who's seen the videos? Who's seen the videos in court? Yeah, most of us here haven't you? And what did Roger do? Arrest that man. Arrest that judge. It's not a completely open-ended power, it has to be justified because we're all entitled to the presumption of innocence. We can't have police going and arresting people for no reason.
They do.
Yes, I see somebody saying that they do. I'll explain why in a moment. You can arrest somebody if it appears to the person making the arrest it's not reasonable practical for a constable to make it instead. Now, there were two constables in the courtroom at the time, weren't they? They were both young in service and young in age. Could we rely upon them to make the arrest?
No.
Well, the reason is they probably didn't know what they were doing. Well, in fact, this is sub judice. We suspect they didn't know what they were doing. So that's the reason we had to do it, because the constables didn't know anything about it, what was going on. In other words, if a constable is present at the scene of an indictable offence, which treason is, he should make the arrest and a private person should assist him. But the two problems. Constables know nothing of treason until Albert came along. Where's Albert? When I signed up 35 years ago probably now, it was in the textbooks and everybody was taught it. And there wasn't a problem. Treason, sedition, that sort of thing. And there used to be, policemen used to have an ambition during their service to arrest somebody for every possible crime in the book. Well, I almost helped in the treason arrest, so I'm quite pleased with that. I've arrested people for murder before now, but treason is more serious than murder. Harold Wilson removed the teaching of the Constitution from the British education curriculum in the 1960s and 70s. It's barely mentioned in police training. The legal syllabus, that means the syllabus that lawyers study, it's in there, but they don't actually ask any exam questions. So if you're a lazy lawyer, you don't even bother learning it. Roger has told me, a cousin of yours is in police training school at the moment, and she has been told that the common law doesn't exist. So we've got police recruits being told the common law doesn't exist. And that's treason, so we're going to get back to that one, aren't we, Roger? Albert's already talked about Chapter 45 of Magna Carta. We will appoint as justices, constables, sheriffs, bailiffs, only such as know the law of the realm and mean to observe it well. Is that a reasonable thing to have, is it?
Yeah,
it's not unreasonable to ask for that, is it? There's another problem. The lawful status of constables. Are they real constables, or are they legal constables, or even lawful constables? Here's the traditional police oath. The important parts are our Sovereign Lady the Queen and Her Majesty's subjects. Our Sovereign Lady the Queen and Her Majesty's subjects. Give you a moment to read that. To the best of my skill and knowledge means that police duty isn't a suicide mission. If there's a huge riot going on and you can't possibly win, it's like a soldier, you're allowed to surrender at the last minute. That's what that refers to. And the other, best of my skill and knowledge means you have a duty to maintain your skill and knowledge, and as statutes change, you're expected to update yourself with them. Here's the post-1996 police oath. The key words involved the Queen and all people. Okay, the Queen and all people. Can you see the problem? The effect of the changes. By removing the words our Sovereign Lady, and Albert was the first to point this out, our Sovereign, I knew at the time, but I didn't make a fuss, because I was in the system, brainwashed isn't perhaps the right word, but perhaps it is. By removing the words our Sovereign Lady, the writer of that oath has compiled a document that imagines the death of the Sovereign, which is a treasonable document under the 1351 Treason Act, which restates the common law, that particular statute, doesn't it, Albert? So whoever wrote that document, and whoever administered the oath under it has got a problem when we get round to them. Treason is compassing the death of the sovereign in the physical sense, but also in the legal sense. So if you say she's no longer sovereign, you've done away with her title. Yeah. So treason is a physical thing, killing the Queen, but nobody's tried that lately. But the legal sense as well is equally important. And it's also treason to overthrow the Constitution. There's a case called the Crown Against Thistle in 1820, and plotting to overthrow the Constitution is also treason. So what's been happening in Parliament lately?
Treason.
What's been happening in police headquarters when they write the syllabuses for new recruits?
Treason.
It's treason, yeah. The other issue is who do the police guard and support? Well, Her Majesty's subjects should be the priority, shouldn't they? And there was no need to write to change it for all people, because in fact, a person who's in the country is known as a denizen. They may be a foreign national, but they're a denizen, and the police and the law are there to protect them as well. So there's no need for that.
It's all come from the EU.
The result is that the legal validity of the oath is compromised and persons who have taken it may not be lawful constables at common law. May not be. It's like anything else, the system is adversarial. Until this goes to court, we're not going to be sure. But you can be sure we're going to try and get it to court, aren't we? Yeah, it will be one of the issues that arises out of what happened on the 7th of May. 7th of March, rather. If in doubt, ask the constable which oath he took. Age is not an infallible guide. Police forces have recruited people in their 50s in recent years, and policemen can serve to age 59 and older for the senior ranks. Now that's the way to get a conversation going, isn't it? When did you take your oath? Can you remember what was in your oath? I wonder how many policemen actually know that. Very few. Very few. Now, what I'm going to go on to talk about is some of the legal issues that were raised on March the 7th. The case is sub judice. 2 people have been charged with violent disorder. Now, it's quite a serious crime, violent disorder. In the public order realm, it starts with breach of the peace, which is a bit of a ruckus, to threatening behaviour, which is a bit more of a ruckus, to affray, which is fighting, to violent disorder, to riot. So it's one down from riot, so it's quite a serious charge. But the good news is, you get Crown Court trial in front of a jury. You get the Crown Court trial in front of a jury. And now, what we're saying, jury have a very important power. Very important power and obligation. They can decide whether they think a person is guilty of doing something, and they can also decide whether it would be just to convict him. So, if all blue-eyed boys are due to be put in prison or killed because of a statute, they can say, no, we're not having that. And that's jury nullification. And you can bet when these 2 chaps get to court, they were fully briefed on jury nullification. What happens in the Crown Court at present is the judge doesn't tell the jury about that. They don't tell the jury about that, which is outrageous. And they've got away with it for a number of years. Under the sub judice rule, it's acceptable to publish material as part of a discussion of public affairs or as a contemporary report of the day's legal proceedings, so that's the one I'm using. Roger has experience with the police on several previous occasions, including the constables who called to his trial on the 15th of February, confirmed that ignorant or both. 4 PCs arrived, 2 came in the room, and they did nothing else, did they? They stood there, they knew nothing of what was going on, they didn't listen to the court case. One of them said, we're here to keep the peace. And at the end of the case, when Roger wanted to report a crime, they just disappeared.
Keep the peace, sir.
Roger asserts that he was justified in calling upon members of the public to assist him in making the arrest because it was not reasonably practical the counsel was present in the court. If they don't know what's going on, they're not paying attention, they don't know the subject. Obviously that applies. The mass issue, an allegation of treason against Judge and inverted commas Peake. If Judge Peake had accepted that he was on his oath when challenged by Roger, we'd have wasted the day really, wouldn't we? Because we'd have accepted that. But he didn't. Mr. Peake, it's alleged, was part of a scheme to set up fraudulent courts in contempt of the real common law courts. He refused to acknowledge the common law principles that his oath had been made to and was arrested for treason and contempt of court. For those who've seen the video, Roger read out a judgment going back to 1974 about what a proper court should be. On every particular, Judge Peake, from his previous experience of him, was breaching that. And it was a test. And if Judge Peake had said, all right, I'll roll over, I accept that I'm on my oath, we wouldn't know what to do really, would we? We'd have trouble holding Rusty back, but there we are. Contempt of court. This is a summary of the quote that Roger read through. The due administration of justice requires first that all citizens should have unhindered access to the constitutionally established courts. That's not a new court they invented last week. It's a constitutionally established court, where it's free from bias. Well, in actual fact, when people take to court for council tax, the council hire the magistrates, don't they? Yeah, that's not free from bias. And thirdly, there being no usurpation by any other person of the function of that court. So we've got the common law courts, and the judge wouldn't go on his oath, wouldn't accept that he was bound by oath. So what he did from that point onwards, he was setting up his own court, wasn't he? He was a usurper, which is treason, isn't it? Because it's compassing the death of the sovereign in the legal sense. Now, for those who've seen the video as well, the judge scuttled out the back, didn't he? After having been arrested, he escaped. Now, it's an indictable offence in common law, punished by fine imprisonment for a prisoner to escape without the use of force from lawful custody. A prisoner in custody on a lawful charge includes a person in lawful custody following arrest. So whatever happens, he's committed a misdemeanour, hasn't he? He's scuttled out the back. His only offence really is he thought he was going to be assaulted. He was going to be assaulted. Now, there was a lot of noise in that courtroom, wasn't there? But But was there any violence? No. From our side? Yeah, there was police violence, yeah, that's right. But the important thing is, at some point, the police violence stopped, didn't it? And the constables there went from business as usual, chuck these people out of court, oh my God, they're resisting, oh, I better put handcuffs on them, to hang on a minute, what's going on here? Are we doing the right thing? And that turning point, I think, is historic. It's the self-preservation alarm kicking in. I could be wrong. I could be wrong. And to give credit where it's due, I haven't actually seen a statement from him. There's a police inspector you can see wearing a yellow jacket, and in Merseyside the inspectors have a silver band around their cap. He realised what was going on, he took it in, and what he did then was saying, calm down chaps, and turn the tap off, because he knew that reinforcements were coming from Merseyside through the tunnel and all sorts. And he actually started calming things down, and then an experienced sergeant came in. He had an advantage because he knew what was happening because he'd been spoken to previously, and the experienced sergeant and the experienced inspector calmed things down. But then, unfortunately, some more sort of roughy-tufty policemen arrived and started chucking people out. But in that time frame, it's mainly when Ray is on the table. Yeah, that's when we changed some minds. Yes, yeah. Is Ray here? No.
I was there on the day.
Yeah.
Since then, I was having the hair done in Widnes, and the hairdresser told me that her friend's husband works for Select Security and was hired to go to Birkenhead Courts to protect the judge. They were anticipating trouble.
They're anticipating trouble. Okay. Well,
security owned all the security.
Okay. Well, the lady's just said that she knows a friend of a friend was a security company, and they knew there was going to be trouble.
Nightclub bouncer to protect the judge.
Okay. Well, there was a gentleman in a light grey suit who looked a bit like a retired policeman to me. Who showed up on the video.
Nightclub bouncer.
Nightclub bouncer. There we go. Fine line. These days, not before. So no plan's perfect, but of course we got in. Roger came up with a plan and it worked, so there we go. So we're after judge for treason and escape. Rescue of common law, is a crime obviously, is forcibly liberating a prisoner from lawful custody. Who did that?
Police.
Yeah, that's right. The offence is genuine treason, and the reason it's treason is any arrest, whether private or official, is made in the name of the Queen, isn't it? So if a person's the Queen's prisoner and somebody comes along and takes them away, that's treason because they're dissing, in the modern term, the Queen, aren't they? They're saying, well, never mind, you're the Queen's prisoner, I'm taking you away. So who did that on the day, do you think, if you were in a jury? Is the police, unfortunately? Well, it was the police, yeah. I'm not going to say unfortunately, I'm neutral. It's the police. Is ignorance of a crime any excuse?
No.
No, it's not, no. At some point during the events, those policemen should have been convinced they were doing the wrong thing, and they should have said, all right, we'll let him go. Yeah, and then we'll go and arrest the judge, because the judge must unless he'd run out straight away, he must have still been in the building. Yeah, so he could have been arrested, but he wasn't. Now, misprision and treason. Misprision is the common law offence of knowing the crime's happened and not telling the authorities about it. So misprision and treason is still in force. This is a failure of due diligence in form of treason committed or threatened by others without the assent of the prisoner or any active part in rescuing traitors from justice. So the crowd were shouting treason, weren't they? Yeah. And it wasn't just the treason the judge had done, actually rescuing the traitor was treason as well. So who's responsible for that?
Police.
The police, and it's not just the PCs and the sergeants and inspectors there on the day, it's the chief constable as well. Because in actual fact, Roger immediately, knowing this, he had a duty that treason's been committed. I better go to a magistrate's court and tell them about it. Unfortunately, when we got there, they were shut, so we went the next day. And I'll tell you what happened on the next day. A district judge came out, and Roger got the oath, and the judge had a questionnaire, he had a tick sheet in front of him. But before he got started on the tick sheet, he gave a short speech and he said, justice is too important to be left to the professionals. He said the vast majority of process applications for arrest warrants, that sort of thing, are issued by the Crown Prosecution Service and the customs and people like that. It's very important that the public should get involved in justice as well. And I've got a very good record of issuing private process, but not in your case, Mr. Hayes. And the reason he gave for that came later. The first question he asked is this an offence known to the law? Now, in the kerfuffle, Roger dropped a few pieces of paper, so there's a textbook on the bench in front of the judge, and I found the relevant entry.
Explain that we were trying to get a summons against the Chief Constable.
Yeah. What we were after was a summons for the Chief Constable. Chief Constable Merseyside. So is it known to the law? Yeah, here's the law, fine. How many witnesses you've got? And Roger said, well, about 40. And then there's video. there we go. On the subject of video, in actual fact, there's a statute that says you shouldn't take videos in court, doesn't there?
Yeah.
But duress of circumstances means that in an emergency, you can commit a minor crime to prevent the worst one happening. Okay? So there's going to be an argument in court about use of the video, but what Roger's side will be arguing is we did it because we had to.
It wasn't a court.
And the other thing is, of course, as Roger's saying, it wasn't a court. Yeah? Yeah. Frank's quite right. Once the judge has said, yes, I am an oath, there'd been a problem. There'd be a lot of big cameras putting away, wouldn't there? David said, does the statute require your consent? Now, I've gone down the conventional route because I was trained conventionally, and I've gone down the constitution route, but we're meeting three men in the middle. So what a constitution will say is, when the Crown ceases to rule according to law, first you raise a Barons Committee by writing to every member of the House of Lords. They choose a quorum of 25 of their number, and if they agree that the King or Queen is out of order, they choose 4 of their numbers, originally by lot, because it was quite a dangerous thing to go and see the Queen in the old days, see the King in the old days. They choose 4 of their number by lot, and then they go and serve the paper on the King or Queen saying, sort this out within 40 days, otherwise the population will rise up in lawful rebellion. Yep.
I don't think it's so that there is a statute which is not that we found. What there is, correct or wrong, there is a practice direction which says that if one uses a recording device without the permission of the judge, it may be classed as contempt of court. Excellent.
Well, I don't know if you heard that. It may not be a statute, it may be a practice direction, in which case we can challenge it even further. Thank you for that, I'll progress that. Is that Norman? I can't see through it.
Yeah.
Yes. So, there's the answer. So, yeah, one more question?
Public interest outweighs statute, the law.
That's right, yeah.
4951, public interest, it outweighs everything.
Okay, the lady's saying public interest, and what's happened is, one of the things we're going to talk about perhaps later in the day is we need to exchange information, because we've all got a little speciality from our life experience, haven't we? And we need to share it. So should we talk about the sovereign village? No, okay. We're arranging a conference venue, put it that way, where we can discuss these things, because we all need educating. No one knows it all. Now, the constable's the good news. The history of the police is the history of the police to constable. Essentially, the police force is nothing more than a group of constables working together in the interest of efficiency. The authority of a police constable, the authority of a member of the police force arises directly from his attestation status derived from a common law constable. So everything they do is based on the common law, so they can't say it doesn't exist. So that's why it's outrageous that Roger's cousin is being taught otherwise. The status of the police constable, his powers, whether conferred by common law statute, are exercised by him by virtue of his office, unless he's acting in execution of a warrant lawfully issued, can only by exercising his own responsibility. Now what that means is, the police aren't like the army. In the army, the general says attack, and the soldiers attack. In the police, everything is done from the constable level at the bottom. The constable, all the chief constable can do to the constable is say, come to work, wear your uniform, polish your boots, and stand on that street corner. And anything happens on that street corner is entirely down to the constable. So when you educate the constable, he will do things of his own initiative. He won't need to be ordered from above, he won't need to be told, he'll do things on his own initiative. The other thing to bear in mind is, although constables are liable for their acts, chief constables are also. But not police authorities, but chief constables are. The chief officer of police or police area is liable in respect of any unlawful conduct of constables under his direction and control in the performance or performance of their functions. So that's the reason why Roger goes to the court and wants to get an arrest warrant or a summons for the chief constable. Once an individual constable is educated about the law, no one can lawfully tell him to act contrary to the law. So once we get a grip of these constables, we start educating them. That's the end of it as far as the chief constable is concerned. He's got no more authority over them. police, I'm glad you get that one. The important point is, train the constables correctly, and they will, of their own volition, do the right thing. The majority of them. The majority of them. And those that don't will be arrested by those that do. I remember Albert saying that if I still had my warrant card and somebody committed treason in front of me, I'd arrest him. If anybody else got my arrest him, and eventually I'd be the chief constable because I'd be the only one. That's the ultimate exercise. Okay, so that's my conclusion. Okay, I can't say any more than that. Thank you.